Teams, and it is also being streamed live. The committee for this hearing today comprises Councillor Marie-Therese Rossi and Councillor Dory Schmetterling and myself. Councillors, can you please introduce yourself?
Hello, my name is Marie-Therese Rossi. I am councillor for Redcliffe Ward.
Thank you. Dory, turn your mic on.
Thank you. Sorry about that. I'm Dory Schmetterling. I'm councillor for Pembridge Ward, just north of Notting Hill Gate.
Thank you. Any declarations of interest? Okay. We're joined by Sharon Deball from the council's licensing team. Our legal officer today is Lindsay Lemasurier. Also with us is our committee officer, Anne Wright. Ms. Wright will be monitoring all of our connections and help with any technical issues we may have. She's very helpful. She is supported by Tom McColgan, Gareth Ebenezer, and Luke Curran. Before we start the hearing, just a few ground rules. Please make sure your microphones are on mute until you are invited to speak. And please make sure mobile phones are on silent. I shall do that now. Do keep your cameras on when not speaking if you wish, unless we run into connection problems. Then we'll have to turn them off. Please note that the Microsoft Teams chat function is not monitored, so please do not use it. In addition, this is a public meeting and the chat would not be seen on the live screen. Everyone should have received the procedure for this meeting regarding the use of cameras and how to connect back if you lose the connection. Thank you. So, the case before us today is to grant a license for Walton Cafe, ground floor, 48 Walton Street, London, SW3 1RB. The quorum for this meeting is, the committee is 2, as there is always a possibility that I may lose connection temporarily during the broadcast. I am nominating Councillor Rossi to be appointed as the substitute chair. Members, please confirm whether this nomination is seconded. Councillor Schmetterling?
Seconded, yes, glad to second.
Councillor Schmetterling seconds the nomination. Thank you very much indeed, Councillor Schmetterling. I confirm that Councillor Rossi has been appointed substitute chair. Thank you, colleagues. For clarity, I will outline the procedure of the meeting, which, as already mentioned, has been circulated with the papers and are online. First, the licensing officer, Ms. Teball, will give a brief outline of the application. Please, can you confirm your attendance?
Good morning, Chair. Yes, I'm here.
Then I will ask the applicant's legal advisor, Mr. Philip Stott, to present his submission. He will have up to a maximum of 10 minutes to do so. He is joined by the instructing solicitor, Mr. Kevin Bowles, who may be able to assist members should they have any questions. Please, could you all confirm your attendance? Mr. Philip Stott.
Good morning, ma'am.
Mr. Kevin Bowles.
Good morning, madam.
Good morning. Thank you. Then questions will be asked by members of the committee of the applicant. Then questions may be asked by the objectors of the applicant. Next, yes, the legal advisor. Next, the objectors, Councillor Waller Idris, Mr. Darren Rickard, supported by Countess Elizabeth Balza, and Mr. Lakshman Menon, supported by Ms. Flaminia Gonzalez Balza, will present their objections. They will have up to a maximum of 10 minutes each to do so. Please, could you confirm your attendance?
Yes, for Darren Rickard and Lakshman Menon.
Yes.
Councillor Idris? Okay. Countess Elizabeth Balza?
Yes, in attendance.
Okay. And Mr. Lakshman Menon?
Yes, in attendance.
Okay. Flaminia Gonzalez Balza?
Yes, in attendance.
Okay. Great. Then questions will be asked by members of the committee of the objectors. Then questions may be asked by the applicant of the objectors. Then questions may be asked by the legal advisor of the objectors. After this, we will ask our legal advisor, Ms. Masuria, to deal with any questions she may have, for example, regarding any conditions. Please, could you confirm your attendance? Ms. Masuria.
Present, Chair.
Thank you. Then finally, we'll turn to the governance team to see if any issues have been raised that we need to consider. There will be no summing up and the meeting will end. I would like to remind everyone that the committee has read the papers which comprise the main pack and the additional submissions circulated. So there is no need to repeat their content, but please do draw our attention to certain points and pages, and Anne will move the document on the screen for us. So let's get going.
Hi, sorry, Chair. It's just
Yes.
Anne Wright from Governance.
Yes.
I would just like to say that we have been joined by another objector, Anne Holmes. Can we just check if we can hear you, Anne?
Anne, can I just ask a question, please? Is Anne Holmes one of the official objectors or one of the parties? Or named
Yes, she is.
before?
Yes, Anne Holmes Drury from Walton Street is an official objector. We
Okay,
just didn't
okay.
know that she was coming. But
Okay, thank you.
Ms. Holmes Drury, can we check your microphone if you would like to? I'm not sure if she can. I'm sure she can hear us. I'm not sure if she's just maybe away from her computer, but I just wanted to alert everyone that she has joined the meeting and is an official objector.
Will she be speaking? Or would she request
I
to-
haven't had indication that she was speaking, but let's just see if we can hear from her during the course of events.
She's not listed here.
Sorry, Chair, it's Heidi Tick, another legal advisor. Just to say that if Miss Holmes wishes to speak, she's an official party, she is entitled to speak.
Okay, there was one other question I had then regarding the speakers. We have two members of the same household. Will they split their 10 minutes?
You can ask them how they wish to divide their 10 minutes. It's entirely up to them.
Okay, I think that would be fair if they split it, really, but we will see what they say.
Okay.
Yes, and Chair, just a reminder that obviously two people joining us today are witnesses, so their time would have to be as part of the objector's time. So Countess Bowles' time would need to be part of Mr. Rickard's 10 minutes.
Oh,
and
good.
So they don't have 10 minutes in their own right.
I see. Okay, excellent. Thank you for clarifying that. So that answers my question, really. Okay, now before we start, I would like our legal advisor to clarify the issues of planning and highways enforcement, as well as smoking legislation, please.
Thank you, Chair. Having read the objections, I just wanted to make clear at the outset, whilst issues of planning, highways and smoking can be heard during this hearing, enforcement of the planning regime is entirely separate. Enforcement of highways, pavement licence regimes is also entirely separate. And any enforcement of smoking is dealt with under the Health Act. So they're not for your remit today. You are here and you are concerned with the licensing objectives. Thank you.
Thank you. I call on Ms. Diebalg. Can you outline the case for us, please?
Thank you, Chair. Good morning, everyone. The application before you is for the grant of a new premises licence for Walton Street Cafe, 48 Walton Street, Southwest 3. You may recall that the application was due to be heard on the 27th of April, but but was adjourned at the request of the applicant. The details of the application and summary of the representations are as set out in the body of the report, but there are a few points which I would like to clarify and to add some further information regarding the premises. Firstly, the report refers to the premises as the ground floor of 48 Walton Street, which is in fact incorrect, and my apologies for this error. As can be seen from the application form and the plans on pages 17 and 18 of the committee report, the application is for a licence for the ground floor and basement, including the forecourt immediately outside the front of the premises and the rear enclosed terrace. In addition, the premises has a parklet terrace at the front of the premises on the roadside, which is not shown on the plan. However, as the premises have applied for the sale of alcohol for consumption both on and off the premises, and if the committee is minded to grant the licence as applied for, the sale of alcohol for consumption in this area would be covered under the off-sales element. Both the forecourt and parklet terrace are licensed for tables and chairs. The forecourt is permitted to have 2 tables and 4 chairs, and the parklet terrace 4 tables and 8 chairs until 9 p.m. on Mondays to Saturdays and until 8 p.m. on Sundays. These premises have not been previously licensed to sell alcohol. We understand that the applicant, Mr. Cherry, has been operating the business for approximately 7 months. Mr. Cherry sought pre-application advice prior to submitting his application and has since proposed the conditions which were suggested by the officers. In addition to the representations included in the committee papers, you have a further submission from Countess Elizabeth and Flaminia Gonzalez Barber Bolza, who are witnesses for Darren Rickards and Lakshman Menon, whose representations are included in the committee report. You also have further submissions made on behalf of the applicant, including 4 representations and a petition in support of the application. The applicant has also proposed a list of conditions which are numbered 1 to 15, starting on page 5 of the document titled Written Submissions of the Applicant. These conditions were suggested by our officers as part of the pre-application advice. Since the committee report was drafted and dispatched in April, 1 further complaint has been received on the 19th of May. This alleged that the premises were selling alcohol without a licence at around 5 p.m, that there were 11 chairs in use in the parklet terrace, in excess of the numbers permitted under the pavement licence, and that the cigar smoke was causing a nuisance. One of our officers, David Williams, visited the premises the following day and spoke to the manager, who advised that the owner and some friends had been sampling some bottles of wine in preparation for their obtaining a licence. At the time of Mr. Williams' visit, no alcohol was on display and there were the correct number of seats and tables in the parklet terrace. Mr. Williams also gave some advice regarding the smoking area and the requirement that no more than 50% of the walls of the shelter can be enclosed. I also visited the premises yesterday to familiarise myself with the layout of the premises, and we have some additional photographs available if that would assist the committee. I don't have anything else to add at this stage, but I'm happy to answer any questions the committee may have.
Thank you very much. I do have a question. Can you show us, please, because we weren't clear, where is Walton House in regard to the premises?
Okay, if we can go to page 68.
Yes. Yes, we needed, great.
Yeah, so Walton House,
Yeah.
if you look at it, at the centre of the map, you can see a blue square. Walton House is pretty much opposite the premises. There's a red dot there which indicates Walton House.
Okay, and the premises is?
The premises are indicated by the blue square.
Right, I see that. Okay. So it's not really showing it on the street. That's why I was wondering. Okay. So the entrance to Walton House is on which side? It's on Lennox Gardens or?
I'm not sure, to be honest. The residents may be able to answer that.
Yes, Councillor Evans, this is Darren Rickards. Our front door is right opposite the cafe. So the red dot is a little misleading because
Yes.
the back of the building, our bedrooms face it, and the front door, you open the door and it faces directly into the cafe.
Okay, that's helpful because it wasn't clear. Thank you very much.
Can I ask a question, Councillor Evans?
Yes, please.
Yeah, in the report, the pack, there's allusion to breaches of planning, control, erection of things without permission, listed building consent, etc. But I know there is nothing from planning to outline any of this, so I am a bit confused by that.
I'm afraid I don't have any further information on any breaches of planning legislation. We've gone by the report from the planning officer that's included within the papers to say that what is proposed under the licence is within the permitted use.
Okay, thank you.
Councillor Rossi, it's Heidi Titcombe. I can just say that the planning authority are a responsible authority. They're entitled to submit a representation, and they haven't submitted a representation in this case.
Could I?
Very helpful.
Yeah, thank you, Ms. Titcombe. I just want to ask in that context. Yeah, sorry. In that, it's very obviously it's quite a lag. Could I just ask in this context, as planning haven't said anything, that one of the objections alleges there's an enforcement case ongoing at the moment. I mean, I haven't had a chance to check that, but I'm just wondering, it seems a little bit inconsistent that on one hand, there's supposed to be an enforcement case, one of several, but this is the one that's current, and we heard nothing from planning.
But we're saying that planning enforcement is not relevant. Is that correct?
Yes. At the moment, planning had the opportunity to submit a representation. As they haven't submitted one, you can't say that there are no enforcement issues because we don't know one way or the other. But the matter before you is you have no representation from the planning department.
Indeed.
But perhaps the applicant can, when they're presenting their submissions, that they can comment on that point because they might be able to add some points for you.
Excellent. Thank you for clarifying. Any more questions from the committee?
Not for me, thank you.
Okay. I think, well,
Chair, sorry, it's Heidi Titcombe again. Miss Dybels indicated that she had some photos. If the parties don't object to those photos being produced, it might be helpful just to see the photos just from a layout point of view, if that is acceptable, and no doubt the applicant's solicitor will advise whether he's agreeable or not to that.
Mr. Stott, do you agree to that?
Madam, yes, I do.
Okay. Excellent.
And the residents, do they have any objections to that?
Well, you've not specified what the photos are of, but no objection. Is it possible, Councillor Evans, just to address this point on enforcement?
I think you'll have to wait till you can speak.
Okay.
Thank you. Okay, let's have a look at the photographs and please explain what they are.
Hi, Chair, it's Anne Wright. My colleague Luke is going to go to those now.
Thank you very much.
Okay. So this, okay. So this is the external courtyard of the premises. It was about 11 o'clock yesterday morning, so it was very quiet. There was only a few people outside. So we just wanted to kind of get an idea of what was outside. I think there are covers outside for around 20 people. So that was the terrace. If you can go to the next photo, please. Again, that's the same terrace, just a slightly different angle. But it is quite a small area. This is the basement area, which at the moment has lounge seating. It would be helpful to find out from the applicant what is proposed if the licence is granted, because one of the conditions that has been offered is that the sale of alcohol is only to persons taking table meals. So at the moment, the layout doesn't suggest that it's restaurant seating. But again, we can hear from the applicant during the hearing.
Yes, I agree with that.
This is the ground floor. It's quite a small area. I think at the moment it's got seating for around 20 people. You can just about see through the window. I don't know if you can zoom in on that photo. But you've got the tables, the two tables outside, and you can see the parklet terrace, the seating area for the parklet terrace. Again, this is from the doorway looking in, and there's the bar counter at the back. There was no alcohol at the time of the visit. I think just skip to the next one. That was just a view from the street. So as you're looking at it, the parklet terrace is on the left, just in front of that car.
So is Walton House to the left there?
Yes, it would be. It would be to the left. It would be pretty much directly opposite.
Okay.
I think you can just see a little bit of the corner, can't you?
Yes.
On the corner to the left of the car, you can just see a sliver. That woman is walking towards it.
Yeah. So those are the photos that I took yesterday.
Excellent. Okay. Now for the applicant's case. Mr. Stott, can you please present your submission, and please do turn your camera on if you like. You have up to 10 minutes to do so. And will you be timing him?
Thank you very much indeed, Madam.
I can, Chair. Yes, if you'd like me to.
Yes.
Thank you. Well, Madam, I will keep my submissions within the 10 minutes allotted to me, and I can do so because, as you've helpfully indicated, I have provided on behalf of the applicant written submissions setting out some of the detail that we rely on in respect to this application. And so I invite those written submissions to be taken on board by the committee as part of the overall application, and I hope the panel has them. If not, please do say so. And it may well be that they're about to be called up on the screen in any event, so I'll just pause if that is to happen. Yes, I'm very grateful. Thank you. I set out in those submissions at paragraphs 2 through to 10 the nature and history of the area in question. It is not the case that this is a wholly residential area, and nor has it ever been. It has always been a mixed-use area, even at this northern end of the street. And I set out some of the details, the nearby licensed and non-licensed food offering outlets within about 100 metres or indeed less throughout there. From paragraphs 11 onwards, I attempt to deal with some of the specific objections that have been raised by the objectors who provided their objections prior to the drafting of this document. At 11, as I said, I set out the nature of this street, as may be seen from the video that we provided, the photographs as well. The Walton Street is in itself a relatively busy in terms of traffic, two-way street. There are 2 restaurants, an off-licence and a delicatessen very nearby to the Walton Cafe. One of those restaurants is on Lennox Garden Mews. It's effectively at the back of Walton House, if the front entrance on Walton Street is the front and physically attached to Walton House. 12, I set out the fact that the applicant, Mr. Cherry, lives very close, within about 5 minutes walk of the venue with his young family, who attend local schools and so on. This is clearly a business that is run within the community. At 13, I set out our stance on the history that has been raised by the objectors regarding matters such as planning, highways and smoke can be added to that. I endorse the advice that you have already received from the legal advisor, and I set out in paragraph 13 the relevant part of the Royal Borough's licensing policy, which adopts the Secretary of State's guidance that the planning and licensing regimes are properly separated to avoid duplication and inefficiency, and that the licensing authority will ensure that separation. The planning regime is best placed to adjudicate on any issues regarding planning. On the point that has been raised regarding enforcement, it's not clear to me what current enforcement there is. There's an application with planning in respect of the erection of a light pergola in the rear of terrace, but there's no outstanding enforcement, and if there's some clarity on that, then perhaps I'll be given the opportunity to ask questions of the residents about that when their turn arises. As can be seen very helpfully from the video, from the photographs you've been shown and those that we have provided, this is not the sort of establishment that can be anyway be said to have damaged the character or ethos of the street. It is a high quality establishment aimed at an affluent clientele and not the sort of establishment that would cause difficulties with noise or public nuisance. And in any event, of course, this application is very limited. It only goes till the early evening. It goes nowhere near midnight, let alone past it, and so it simply will not increase any late night public nuisance, which of course the residents would be rightly concerned about. No doubt those objecting would prefer it if there were not any licensed premises near them at all. Also, no doubt they would prefer it if the traffic was much less and there was no smoke or other disturbance at any stage. The test that must be applied is whether or not an unreasonable, i.e. unacceptable, additional disturbance would be caused by the granting of this licence. It is a question, of course, of balance and proportion. And in my respectful submission, bearing in mind all the information that you have, this relatively small premises with a licence aimed at the clientele that it is aimed at and at the hours that have been stated would not cause such an unreasonable disturbance to local residents. As you will have seen from the supporting material, in fact, the views of residents are split. There is a petition with 9 signatories. There are also supporting letters from the immediate neighbour, the upstairs neighbour of the Walton Cafe, and also local residents Mr. Grimmard, Mr. Dresden, who's also a local business operator, and one of the neighbouring trading operations, Mr. Christopher Taylor. So clearly there is a balance of views on both sides, and in my respectful submission, with the very stringent and full conditions with which the applicant wholly agrees that have been proposed by licensing, any concerns about just noise and public nuisance can be appropriately dealt with. Can I raise one additional matter, which is in respect of condition 9, because the issue was raised about the leaving of rubbish on the wrong side of the road, i.e. that side next to Walton House. That, of course, is something that can happen now without the licence, or be an issue now without the licence. In respect to condition 9, which deals with refuse, the committee, if it's concerned about that, may wish to add something along the lines of no refuse shall be left on the eastern side of the carriageway or footway of Walton Street. No refuge shall be left on the eastern side of the carriageway or footway, and that should hopefully ameliorate that concern. Putting it all together, in my respectful submission, this is not the sort of application that will cause late night noise at all. Walton Cafe is not responsible for any of the other issues that have been raised in terms of late night traffic or other disturbances late at night, and this application will not add to them. And so for those reasons, we invite you to grant the application along the lines of course it is a matter for the committee, the conditions which have been set out as by licensing and the police. And of course, we rely on the fact that it is of note that there is no specific objection to the grant of this licence by either the police or licensing or planning or any other relevant arm of the local authority or law enforcement. And Madam, those are my submissions.
Thank you very much, Mr. Stott. Now we'll have questions from the committee. I would like to pick up your point on the rubbish. Can you tell us what time your rubbish collections are, the present operator you're using, and where will the rubbish be left?
Madam, I wonder, because I will have to take some instructions on that direct from my client, whether it's better to receive all the questions in one go, and then I take the answers, and then I give the answers to all the questions, whether that would be a more efficient use of time, or whether you want me to do it one by one.
Well, sorry, I don't understand. You have to go have an adjournment in order to talk to your client, is that it?
Madam, I will just ask, I'm going to have to turn my camera and mic off just to get the answer to those questions. I'm very happy to do it one by one. It may be more efficient if I get all the questions and then just pause briefly to take those answers.
I'll ask our legal advisor. Procedurally, can we do that?
Yes, of course you can. However
we can. Okay, so I'll go around the committee. We'll each give our questions. So I'd like to know the plan for the rubbish, please, and where you plan to leave it. With every professional operator, there usually is a schedule. So the other thing I wanted to know is how you're planning to do food, because what we saw there was looked like a bar as opposed to a restaurant. So give us your plans and how you plan to address that. Is it microwave food or is it a kitchen? It doesn't matter, but we just need to know. And the third thing on mine is where is this cigar room that was listed? Because there's no smoking inside. So how do you plan to have a cigar room? So those are my three questions. I go to Councillor Rossi.
Yes, Mr. Stott, in the application, your client suggests that he is more than happy to have regular meetings with residents, but some of the objectors here today suggest that the relationship has not been that good. So going forward, how does your client plan to have regular meetings with the residents to make sure that problems don't arise in the future? That's my right.
And Councillor Schmetterling?
Yes, thank you very much. Mr. Stott, you've obviously addressed a number of the objections, but I was just wondering, you said that a number of the violations of planning and so on, which I know are not directly related, but they do give an indication of how the premises might be managed. So you're saying that some of these violations, and I exclude the neon sign business because that appears to be an accident anyway, a one-off. It's just to do with a former partner of the current owner, is that right? And is a clear time division between the present managerial arrangements and the previous ones where apparently there were a number of issues? I mean, there's, let's say 3 other enforcements from the historical enforcement issues. Can you just give us some information about that, please, about when the new management started?
Thank you.
Thank you very much. If you'll give me just a couple of moments, I can get those answers. I already know some of them, but I'll check the others.
Okay. We can take a 2-minute break then.
Madam, thank you very much indeed for the time.
Pleasure.
I can go through those questions and answers. The first question was from you, Madam, in respect of the rubbish collections. The situation is that the rubbish collections are done by the council's own service. The rubbish is put out at the close of the business day, currently around 7 p.m. We understand that they're collected at some point shortly after that by the council on its own schedule for that particular part of the street. In respect of food, I apologise, none of the photographs that we provided, nor any of those taken by licensing, showed the kitchen. I've been to the premises and so I can describe it. On the ground, the lower ground floor, the basement floor, one goes down and then there's that lounge area which you saw in the photographs, and next to that there is a small kitchen. I say small, it's the sort of kitchen which often caters for premises of this sort of size. And so it's proper cooked food that is being offered currently as part of the cafe offering. And I hope that answers that question. In respect of the downstairs area, it's obviously laid out as a lounge area, coffee lounge area currently. There was some discussion about the concept of whether or not there could be a cigar room. If the alcohol licence is granted and there's sufficient demand to use the downstairs room for the food offering and alcohol offering, then it will be converted into proper restaurant seating rather than an indoor coffee lounge type. In respect of the meetings that have been proposed, I accept obviously that relations with some of the residents are clearly not good on the face of the papers. As the committee will have seen, relations from some other residents are very good, both the traders and local residents. Mr. Cherry obviously would want to have good community relations. He's very happy to host the regular meetings. They would no doubt take place most conveniently in the cafe itself, after hours or downstairs in the lower room if it's not being used or something like that. And then it could be easily held on that regular basis, which has been proposed, I think, by the police condition, on a 6-monthly basis or so, with suitable advertising beforehand. In respect of the planning issues, I obviously accept what has been said about them. The situation is this: Mr. Cherry's former business partner was bought out by Mr. Cherry in October last year. The various issues arose before that, as I hope I made clear I think in July, was when those retrospective applications were made. And then in November, as the records will show, they were withdrawn and the items were taken down by Mr. Cherry. He bought out his business partner, he's now the director and I think the sole shareholder. And so I hope this answers those questions.
Thank you. Okay. Are there any other questions from the committee?
Not
And
from
now, yes?
Hello.
Okay.
Hello.
Yeah, we'll
My
now
team
take.
keep-
Sorry, who is that?
That's Dory. Sorry, I'm having a slight technical issue here. I might have to switch devices. I just wanted to say I was just checking there. I must admit there doesn't seem to be an enforcement case going. I just looked, but it's just odd that the people are so worried about this. We just have to find a way, if granted, to allay people's fears. And I mean, I would take this opportunity of saying to residents that if they do have any issues, to please report them through the report a problem page on the day, and not wait for a hearing of this type. Thanks very much.
That's very helpful. Thank you. Okay. Now, are there any questions from the objectors?
Yes. It's Councillor Evans. Darren Rickards, I want a few things, because behind this question really is our perception that they remain a bad operator, not just in the past before this, the convenient shareholding change in October. So, for example, the neon was dismissed as an accident, but under the threat of legal action, that should have been removed last September after 2 enforcements.
Okay, that's a planning issue, but you can raise it now.
I agree, but it speaks to character and behaviour patterns. Secondly, a summation before this began was that on the 20th, there was a visit by RBKC, and given the violation with 11 seats in the parking bay, there is a formal submission of photographs that took place on the 22nd, so barely 2 days later, but they had 12 seats in the parking bay. So
sorry, these are supposed to be questions now.
yeah,
from you.
That's my question, which is
okay.
to the other side, in terms of how they can credibly claim that there has been an effective transformation in ownership and behaviour. You seek to exonerate Mr. Cherry on the basis that all the past mistakes were taken whilst he was in the room, but somehow not involved. You say in your third paragraph that he has a decade of experience of hospitality, all aspects of hospitality. And Mr. Dredgton is even telling us that...
Can I have a question, please, not a lecture? You'll have your 10 minutes.
What evidence can you give us that the transformation is real, and that he was completely not involved with things in the past? It just doesn't sound credible.
May I have one question to ask.
Who is that?
This is Lakshman Menon, one of the...
Yes, please do. You want, Mr. Stott, would you like us to give you a list again?
I think that might be most efficient.
Okay, so Mr. Menon, please ask your question.
The applicant has submitted that there was one violation of an enforcement order against the use of neon lighting. One single violation. This is absolutely incorrect. I'm quite willing to give you the multiple.
I'm asking for a question. You'll have your opportunity.
The question is, this is an incorrect statement. Is that not so?
Thank you. Okay, Ms. Gonzalez-Barba, did you want to have a question? Nope.
Yes, I would.
Okay, thank you.
I'm just saying, I have a question in relation to the illegal roof that they built back last year without having planning application nor listed building consent.
Let me ask our legal advisor, can she ask a question regarding the planning and on what
it's related?
Any questions pertaining to enforcement really are for the planning department. They're not really for the licensing committee today. If, as Mr. Rickard mentioned earlier, it goes towards character and perception and how they're going to move going forward, then you can ask a question. But obviously, planning enforcement isn't an issue for today.
I understand that, but it's very much related with the nuisance that we've already experienced throughout that period for the last 2 years, basically. I live 50A Walton Street. I'm directly a neighbour to this Walton cafe.
So what's the question you're asking?
I'm attached. So my question is, how do they plan to keep the nuisance down or not create a nuisance when they're using a residential garden or garden space that is next to my garden?
So basically regarding noise.
Yeah.
Is the question. Okay, thank you. And Countess Balza, would you like to ask a question?
Yes, one of my greatest concerns is the terrible and permanent amount of smoke, cigar and cigarette smoke that is permeating our house, both from inside and outside. And it is absolutely unbearable.
Can I have a question, please?
It is unbearable. So what are they going to plan to do about this?
Thank you. And Councillor Idris, did you want to speak? No. Okay.
Sorry, Chair, just to confirm, Councillor Idris didn't join the meeting this morning.
Oh, okay. Thank you very much. I'll take her off the list here. And
Chair.
Yes.
Sorry, just forget it. I wanted to ask a question, but I just have to think about it for a minute. It was something that arose from what the other people have said, but allow me to think for a moment.
Okay. Well, we're asking now questions from the objectors. Right. And did any of the witnesses have any questions?
Yes, you've already asked the witnesses, Chair. That's Countess Balza, and yes.
Oh, okay, fine. Thank you very much. I thought you may have additional witnesses. Okay. Mr. Stott, would you like a moment, or can you answer these questions?
Madam, perhaps if I just take 1 minute. Thank you.
If anyone needs a comfort break, you could run quickly.
Well, do you want to call, say, 5 minutes? Make sure we're all back if we do go.
Give it 3 minutes.
Well, so, you're being optimistic, but okay.
Just go. Thank you.
Madam, I'm ready to begin if everybody else is.
Okay. Is my committee back? Marie-Therese, are you back? Dory, are you back?
I'm back, Janet.
Thank you. Councillor Schmetterling?
I think we'll need to give him just one more minute.
Okay,
Chair.
thank you.
Oh, hello, Chair.
Oh, excellent. Thank you very much, Councillor Schmetterling, for speed. Okay, now I have questions, please. I'm inviting questions from the legal advisor, Ms. Masurier.
I think the applicant's going to answer the questions for the objectors first of all, Chair.
Oh, okay, fine.
Thank you. I'm very grateful.
Yeah.
Can you hear me all right?
Yes.
Thank you. Madam, in respect of those questions, insofar as there were questions rather than repetitions of the history and the objections, from which I'm sure you will hear more about directly from the objectors and witnesses in due course. The evidence in respect of whether or not there has been a real transformation and is actually linked to the question of enforcement and planning, because the committee will realise and understand, I hope, from the information that has been provided, how the history of this has worked. We say that there has been one violation in respect of the signage. I repeat, it's not a neon sign, but it was a backlit sign, since Mr. Cherry took over full time, and that happened in the circumstances in which I've set out in the written submissions. True it was that there was some enforcement action before that point, but that was in the situation as to the management as it then was. Similarly, the issues about the retrospective applications for planning in regards to what was happening in the back. I would not wish the panel to place too much emphasis on this. Obviously, compliance with all kinds of regulations is an important factor when considering the grant of an alcohol licence. But as I've already said, firstly, the planning regime is properly separated from it, and secondly, retrospective applications for matters such as what is required in respect of businesses and listed buildings and so on are not that uncommon. They do happen. The question is, how long do they go on for, and whether or not, when matters are raised and enforcement is brought about, matters are actioned. And that has happened in respect of Mr. Cherry. That which was erected in the back was taken down, and so on. The cigar smoke that is suffered, or cigarette smoke that is suffered, obviously is an issue regardless of the alcohol licence, and indeed something that only applies to the outside areas. It can be dealt with, of course, by the closing times that have been set out very firmly in the conditions that are proposed, and indeed, of course, the numbers of people that are able to be in either the rear area or the front area at any one time in accordance with the planning and tables and chairs licences. So I'm not sure I can go any further than that. Of course, the smoking legislation is again a separate matter dealt with by a separate regime and the subject of its own statutory regulations, as Madam you have pointed out. Madam, I think you may be on mute.
Yes, sorry. Any more questions?
Chair, a question actually to the one question to the applicant, more question of clarification has occurred to me, if I may ask it.
Let me ask the legal advisor, are we allowed to ask a supplementary question at this time?
Yes, of course, Chair.
Okay. Yes, you may go ahead.
Thank you very much. It's the question of the smoking room. I think you said what you might want to do with this area, but you didn't actually say or address the question of the name of the place called Smoking Room. So what do you plan to do about that? Because obviously one can't smoke inside premises.
Exactly.
So you're absolutely right. One can't smoke indoors. I think there may be. You'll have to give my opinions on this. I think there may be certain exclusions for those selling cigars or something like that. But in any event, if this alcohol licence is granted, as I said, the proposal would be for it to be the restaurant seating and the food service area if business were to justify its expansion down into the basement area. It obviously will, I imagine, will be slightly time dependent as well, perhaps slightly more weekends than on the Monday.
Sorry, I couldn't hear that last bit. Are you sitting in the back of a room, obviously? So could you please repeat that last bit, the last 2 sentences?
Yes. So I said that the what is currently a lounge area, I think there was, as I said, there was a concept about a cigar room that obviously couldn't comply with the legislation. There may be some exceptions for those that sell cigars, but if the alcohol licence is granted, then it would obviously be the plan B, provided the business was sufficient to justify it, to use it effectively as an overflow and provide alcohol and food rather than any other use.
Thank you. Perhaps the legal advisor could comment on this aspect of possibly selling cigars in there. Would it be better to change the name of the room?
I can't comment on the exception to cigars, but obviously, as far as I'm aware, under the Health Act 2006, it's illegal to smoke inside. So obviously, the applicant would need to make sure that they operated within the parameters of the law. So
you could potentially buy a cigar but not use it inside?
Possibly.
Possibly. Okay. Thank you very much.
I might be able. Sorry, Sharon Dyball. I might be able to add just a little something on cigars. There is an exemption in the Health Act for specialist tobacco shops where you can sample cigars and pipe tobacco, but you cannot just sort of have a cigar area where you can just sit and smoke it in a licensed restaurant.
Right. So the question: could they sell a cigar with the patrons then leaving the interior, going outside to smoke it? And of course, that creates the smell for the residents, because cigar smoke is, of course, however pleasurable it might be, it's still very strong. It
would have to be a specialist tobacco shop for cigars and pipe smoke. That is my understanding, and there are then additional restrictions as regards it not being accessible to a public area, which is effectively a non-smoking area.
Right. Okay.
Madam, I agree with that analysis of the law. Perhaps if it is a concern, that can be dealt with by the addition of a simple condition which says something along the lines of tobacco shall not be offered for sale on the premises if it's necessary.
It might also be a good idea, Mr. Stott, to recommend to your client to change the name of the cigar room, because that leads to all kinds of things. When you have people in a licensed premises, they'll start arguing that it's called cigar room. So you might want to suggest that.
Yes, I don't think it's labelled as such in the restaurant, but that certainly it wouldn't be advertised as such, because it would lead to that misunderstanding.
Might be helpful for the residents. Okay, any more?
I've got a question,
yes.
Chair.
Yes, I was just going to call you, the legal advisor, please.
Thank you, Chair. I just wanted to clarify what Ms. Dyball said earlier on. Could we go to page 17 of the pack, which shows the plan attached to the premises? I just wanted the applicant to confirm, because there isn't a red line on this plan, I wanted them to confirm the extent of the on sales, which I believe Ms. Dyball mentioned earlier. So the on sales would cover the entire inside of the premises plus the rear courtyard garden. And also, are you including is it 4 tables and 2 chairs directly next to the premises as part of the on sales? Sorry, four tables and 8 chairs, or whatever's allowed under the current pavement licence.
Can I just clarify, actually, on the plan, it does show 4 tables and 8 chairs, but actually the forecourt is only licensed for 2 tables and 4 chairs currently. So,
yeah.
So
if Mr. Stott could clarify whether the on sales cover the inside of the premises, the rear courtyard, plus the 2 tables and 4 chairs under the pavement licence, but not the footwear extension licence.
Madam, yes, that is my understanding. The plan is slightly wrong because it should be 2 tables outside the front and then there's 4 tables in the parklet bay. My understanding is, as set out, that it by your legal advisor, that's the proposal for the on sales, and I think it's right that the off sales would then cover the parklet, as mentioned earlier.
Sorry, one other question: will your client be doing deliveries, like people, having that Deliveroo, or people coming in for takeaways, or is it just purely people eat on the premises and no takeaways at all?
He doesn't offer that now.
Okay. So we don't have to worry about couriers coming along and collecting alcohol as part of a meal as an off sale. Okay.
He certainly doesn't offer it at the moment. No. I don't think there's no plans to.
Thank you. I think that's my questions.
I hesitate just because if there's another coronavirus pandemic, things obviously change in terms of how businesses can survive. But that is the application is as the application currently is.
Yeah, I think I just asked that in terms of adding conditions for later on, but we can obviously touch on it again at the conditions session. So, thank you. That's all my questions for now.
I make it very clear that Mr. Joe would comply with any conditions that would be put on.
Thank you.
Could you please explain to us what you plan to do in the garden?
You've seen the picture, I hope, of the garden. I think it's right to say I think there's maybe about 13 chairs, not 20, out in the garden. It's a relatively small space. That is currently used for the service of the food that the cafe offers, and so the same would apply, and the application is in respect of the rear terrace.
I see. Okay. Anyone else? Now, for the objector's case, we will start with Mr. Rickard.
Chair, do you want to just clarify times? Mr.
Yes,
Rickard
please.
And Countess Bolzer will between them have 10 minutes, and Mr. Menon and Ms. Gonzalez-Barber will have between them 10 minutes to present their cases.
Exactly. Okay, that makes sense. Thank you very much. Okay, Mr. Rickards.
Okay, I'll be quicker than expected. The timing wasn't clear before this, and please bear in mind not everyone can afford a barrister. I just want to address the 4 supporting letters and the petition that's been presented. On the letters, on the question of the licence itself, there is confusion about what is being asked for, and it's very unclear what they're trying to represent. Mr. Grimman supports a licence till 8. Mr. Monge prefers 7 p.m. Mr. Dresden likes the idea of 8:30 p.m. So I'd like to know what the briefing was on the request. They don't seem to be sure. 3 letters are written by people who live much further away from our witnesses than we do and are simply not impacted by the nuisance from the cafe. And therefore, with the greatest respect, these should be ignored. Mr. Christopher, who does not live here, focuses on his own narrow commercial interests, which are irrelevant. The 4th letter, and I don't mean to be humorous, but the signatory should have attended because I spent 30 minutes on Google Advanced Search with every iteration of the name, showed no records, including on the electoral register, other than Mr. Miguel Monge, who's a specialist in alternative medicine in El Salvador. On the petition, without exception, all the signatories live much further away than us and simply aren't impacted like we are. There are 9 signatories in total, so this can hardly be represented as a ringing endorsement of the local community. The covering preamble is key because it doesn't explain anything. What is the licensing proposal, the closing time, the type of operation and proposed conditions and restrictions? There's also no balance committee, by which I mean, would these 9 have signed if they had known about the enforcement orders, the nuisance to neighbouring residents? The preamble wording, frankly, is nothing more than a love letter to oneself, and we must not underestimate ordinary good people's willingness to sign things like this to appear helpful when they are asked to do so. I would respectfully submit that from a licensing hearing perspective, given that no signatory is impacted as we are, and given the vague emptiness of the preamble, this petition is not worth the paper it is written on. I'd like to invite Elizabeth, please, to come in at this point. Elizabeth?
Hello, yes. Let me first start off by explaining to you, if you could just briefly go back to page 17, where you can see the layouts of the coffee shop. I would like to tell you where exactly our front door is located, because we are immediate neighbours. Now it is where I've got the arrow on right now. So this is exactly the width of this space goes straight, we walk straight into the chairs. Okay.
Sorry, can I just interrupt? It's Anne Wright from Governance. Unfortunately, we won't be able to see your arrow. So if you could just try and speak us through where you're pointing. Thank you.
If you look at of course, if you look at the map, there is you have the wall, and then you have the 4 chairs indicated with the 4 tables outdoors, right? Now that part of the wall right next to the right chair, the table, is our door, our main door, whereby we have to exit and enter virtually through the coffee shop and almost fall into it when we get out. This is just to mention this. Now, first of all, I'd very much like to thank you, the members of the committee, to finally give me the opportunity to speak. Our house on Walton Street 50A has been lived in for 3 generations for now. First my parents, then myself, and now my daughter. It is our beloved family home where we all meet regularly and where my old mother is still a frequent visitor, whilst I also come out on a regular basis. My daughter has lived there permanently for the past 5 years. It is us women of 3 generations who mainly use the house on our own. We are immediate neighbours of the coffee shop. Our house is directly adjacent to the facade of the cafe. Our garden is also directly adjacent to the Walton Cafe back garden. Our view from all levels of our home, both at the street front and at the garden front, directly overlook the outdoor spaces of Walton Cafe. Our front door entrance is immediately adjacent at a distance of less than 1 foot from the chairs and tables of Walton Cafe. When we open our front door, we virtually fall into the Walton Cafe, as there is no safety distance provided to give us any form of privacy whatsoever. I speak to you today not only as a mother, as a daughter, and hopefully also soon to be grandmother, but as a peaceful resident who loves our beautiful neighbourhood. I'm speaking out today because I feel that the committee needs to know the reasons why we are absolutely terrified of the possibility that this highly unreliable operator might be granted an alcohol licence. And I will explain to the committee why. We literally feel besieged by the men running the coffee shop. They're constantly observing us from all angles, from both inside the house, from the back garden, and each time we enter and exit our home. We feel extremely intimidated and scared of the bulky men who run this untrustworthy operation. They're on a constant guard on our doorstep, cross-armed, and we can feel their stares and they're monitoring each and every one of our movements. Even when we meet them somewhere else in the vicinity, they stop and stare at us, cross-armed. I would like to stress that we very much believe in the right of people to earn their living in a peaceful and orderly manner. Indeed, we are frequent guests of Scalini and diners who have never given us any cause of complaint. We have excellent relations with all our neighbours in our peaceful neighbourhood and would be more than happy to have a nice, proper coffee shop in the nearby vicinity. But sadly, this establishment is and never was intended as a coffee shop and has only acted in bad faith and with utter disregard to the neighbourhood from the very start. One only needs to take one look at the layout of the illegal rear extension and the interior design that looked like a nightclub until it was finally removed by the enforcement order. Also, what coffee shop offers a full cigar menu? Walton Cafe is a constant source of disruption to our lives. We're suffering from disorder, public safety issues, public nuisance, noise, violation of chairs and table license, and unbearable cigar smoke and food smells. Should an alcohol license be granted, all this would only get infinitely worse. Walton Cafe represents a public nuisance and disorder for various reasons. Firstly, Walton Cafe has a long history of illegal construction, resulting in a pattern of enforcement orders against Walton Cafe. Secondly, Walton Cafe is also a source of public nuisance because of the violation of the number of people allowed to be seated outside and the violation of tables and chairs license, thereby giving us even less space to enter and exit our home. The chairs are so close to our doorway that we basically directly step into the coffee shop sidewalk tables. This means that we feel very unsafe each time we exit our home and set the alarm before locking the door. The alarm makes a loud beeping sound when it is set and the house exited, thereby signalling to all around us that we're setting the alarm and vacating the house. It feels like drawing cash from a cash machine in the middle of a closed group of people. We are being constantly observed, not just by the owner of the cafe, but also by their clients. And each time we leave our home with a suitcase to travel abroad, we are virtually signalling to the coffee shop and their clients that our house is now free to be broken in. Walton Cafe's violation of permitted operating hours has created an additional nuisance to us, and we are very worried this could be repeated. Walton Cafe has already publicly served alcohol twice on the street front tables without a license, and there are photographs to document this. This has led to a substantial group of inebriated people making loud noise right under our bedroom window. If alcohol was now to be granted on a permanent basis, the noise levels and smoking would only get worse. We're experiencing additional disorder because it is often impossible to simply enter or leave our home because we have people sitting on our front steps, thus virtually blocking it. This is very intimidating, particularly for my daughter and for my old mother. Lastly, I would make a few comments on crime. I'm worried that an alcohol license would only increase the possibility of crime being committed on our doorstep and the risk of us being burgled or attacked and our home broken into by individuals using the coffee shop space to camouflage their intentions and or by inebriated clients. As explained, our door is so close to customers.
Okay, you'll have to wrap up, please.
I haven't finished, I am wrapping up. It's so close to customers that any individual could simply jump in with a single step when we open the door. We really have lost all privacy when entering and exiting our house because the clients and staff almost literally fall into our home when we open the door.
Okay, we'll have to cut you off now. You're past the time limit. Thank you.
No, I don't believe I am, madam.
Actually, you are. Our officer was timing you. You had 10 minutes together.
Well, I have not timed myself right now, but I did earlier, and I was it was only 3 minutes to read the statement, which I haven't finished.
And, Chair, can I interject here, please? The Chair will be able to ask the witnesses and the objectors further questions, and you can elaborate further in the questioning session if that's any help.
Exactly. So
I have very important health and safety issues that I would need to mention, and also vulnerability of children. I also have third-party witnesses in writing who can attest to the level of smoke and fumes in our house on a constant basis.
Perhaps the members can ask you that by way of questions in question session.
We were, if I may say so, assured by our counsel that there would be no time limit on our statements.
Well, I'm sorry, they were wrong, and we can ask you questions. If you continue to argue and don't allow us to carry on, I'm sorry, we'll just have to close you off right now. But we'll be very happy to ask you questions regarding the issues, because there are many issues that are relevant. Not all of the things you're discussing are relevant. I'll give you 1 minute to sum up.
Thank you. Now, health and safety is a huge issue for us because we can literally not open our windows anymore. We are thus permanently subject to living in these unhealthy conditions. The smell of food is equally unbearable and permeates our entire home. We have a third-party witness to testify for this, as we had rental guests staying with us who left for the sole reason that they could not bear the smell in our house. The last thing I would like to mention is the protection of children from harm. The terrible nuisance and stress my daughter has suffered permanently over this past time has made her, in fact, so fearful of starting a family in case the fumes impact her pregnancy, and has left the house. If an alcohol license granted, our home would not safeguard the right of protecting my grandchildren from harm. Our garden would also be unsuitable for children to play because of the smoke and the foul language we frequently hear from neighbours and customers. And lastly, I really am extremely worried about my daughter's safety, since she's on her own most of the time. But we are not the only people who are afraid. Many of our immediate neighbours share our concerns. They have shared their anxiety and the impact of the smell of food and the smoke is having on their businesses. They are also suffering, but they are simply terrified to speak out.
Thank you very much. I will now call on Mr. Menon to speak. And you and Mrs. Gonzalez Bolza, or Barba, sorry, you can split the 10 minutes as you wish.
Thank you, Chair. I shall be brief. I just want to say, firstly, I'm not a NIMBY. I fully support the excellent operations of Dinings, the restaurant above which we directly live. We have frequently been customers of theirs. I do have a problem with the nuisance, the health and safety issues, and the constant nuisance of Walton Cafe. I'd like you to now please hear my witness, Flaminia.
Thank you.
Thank you, members of the committee, for giving me the opportunity to speak. I'm the co-owner of the property right next to Walton Cafe, 50A. I'm directly impacted by the operation of this business. My home and garden are adjacent to 48 Walton Street and its rear garden. This cafe has been a source of permanent nuisance for nearly 2 years since the illegal construction site started. The stress, nuisance, and fear I have experienced have been so terrible that I actually had to move out of my house. This has resulted in the need to temporarily move out. Sorry, I have lost my home. I can assure you, members of the committee, that any reasonable person in my situation would have also temporarily moved out of their home for the reasons I will now explain. I'm absolutely terrified about the idea that this irresponsible operator may now be granted an alcohol license and compromise not only my well-being, but my future children's well-being and safety. The nuisance and stress started way before the cafe opened and has been ongoing, as I mentioned, for nearly 2 years. It started end of 2020, when the cafe illegally started a working site without planning application or listed building consent. Back at the time, it was lockdown. And I was the only person with direct access and view on what they were doing. I was by myself. I took photos and immediately reported this to the RBKC, who sent numerous letters to the operators of Walton Cafe, asking them to suspend works, but these were all ignored. I called Mr. Matthew Evans from planning on a weekly basis for over a year and a half. I took photos which I shared with RBKC and other neighbors on a regular basis. The operators of the business were well aware from the start that I was against this building site. They were monitoring my behavior and would give me dirty looks each time they saw me take photos and each time I walked out of my house. The manager would be standing up next to my front door, crossed arms, when I was leaving. I felt observed and very unsafe as a female living alone. I had to buy blinds to avoid them looking into my home from my rear garden and live in the dark. I have been unable to use my garden ever since. Since then, and since the cafe opened, The nuisance has now transformed into a permanent fume nuisance, noise nuisance, and just a permanent fear that has made me move out. I will explain in detail each of them. First, the fume nuisance. Since the cafe opened, there has been a permanent food, cigar, and cigarette smell. The smell comes from both the street side and the rear garden. The smell is permanent and is experienced with closed windows. And it gets even worse when I open my windows to get some fresh air. As a result, I'm unable to ventilate my home to get fresh air, impacting my health and safety and compromising my well-being, particularly at times when temperatures in London raise. I'm unable to use my garden as I have permanent cigarette, cigar, and food smell. I do not want my future children to play in a garden surrounded by cigarettes and cigar smell and compromise their health. Secondly, noise nuisance. The noise is permanent and diminishing and compromising my well-being. It starts in the early morning when the staff arrive and start putting out the tables and chairs. It continues throughout the day and goes well beyond the closing times when the staff clears out the tables and chairs. And this is experienced 7 days a week and has materially compromised my sleep. Since the cafe opened, I permanently have noise from the cafe visitors, from both the street side and the rear garden side. Despite having my windows closed, I hear the guests' foul language, conversations, laughter from any room in my beloved home, despite having windows closed as mentioned. I cannot use my beloved garden as the noise in the rear garden of the coffee shop is amplified through the back walls that face Walton and go to the mews, the back mews. I'm unable to sleep for the same reasons. The situation is already bad enough, so bad that I had to temporarily move out of my home because I could not bear this situation any longer. I really want to move back to my home and raise my future children there. I'm scared of how bad the nuisance would become if an alcohol license is granted. Any reasonable person knows that alcohol makes people speak louder, smoke more, use foul language, and ultimately lose their inhibition. An alcohol license would result in aggravated nuisance and compromise even more not only my well-being, but my future children's well-being, and I'm planning to have. Again, I would not want my children playing in a garden which is not only compromising their health because of the fumes, but where they're also exposed to the use of foul language by the cafe's visitors. Thirdly, fear. I moved out of my beloved home, not only due to the unbearable nuisance that I just explained, but also because I felt extremely frightened and I'm scared of my personal safety. The dirty looks the operators give me makes me feel as if they wish to scare me, and they have actually succeeded. They monitor every step I take. Each time I leave my home, they're looking at me. Very often, I have people from the coffee sitting at the doorstep of my entrance. I feel unsafe when I open my door as a female living alone. I'm scared somebody will try and get into my home due to the proximity. I permanently feel threatened. An alcohol license would only aggravate this and make it unstable to raise my future children in such an environment. Dear members of the committee, my biggest desire is to return to my beloved home and be able to use my garden again and raise my future children. My future children would be the 4th generation in this family home. The nuisance experienced so far by the presence of the cafe is already compromising this. But can you imagine how terrible it would become if an alcohol license would be granted? Would any of you members wish to raise their family in these circumstances? I'm certain any other reasonable person would sympathize with my situation and feel that an alcohol license would only aggravate the situation and endanger my safety and my children's safety. I want to return to my beloved home and I want to live in peace. This is all I'm asking. I please beg you members of the committee to refuse the alcohol license application.
Thank you very much. I would like to know, I have a question of Countess Bolza. Can you tell us how much time you spend at the house? The reason I'm asking, because I note that you live abroad.
Yes, I come out frequently, approximately once a month.
Okay. And on these occasions, you have been affected by the situation that you mentioned?
Very much so. And so have my guests when, when in short periods of time, when we have rented the house for short periods of time, they have also experienced that. In fact, we've had an instance of them moving out because of the terrible smoke and noise.
Right. So the house is rented.
No, it's not. It's on a short-term basis, only very occasionally.
So Airbnb then?
No, because my daughter's moved out now. So it's recently being rented out when we're not in the house ourselves. It's a temporary solution and a very recent.
Have you made any complaints to the police or to the noise and nuisance?
Yes, we have. Yes, we have.
I see, because we didn't see any submissions that you've made complaints.
Councillor Evans, could I ask a question?
Please do.
To any of the objectors, you kind of touched on it. The planning is a responsible authority, and they have not put in a report to this committee, so we can't discuss the planning things. But normally in these circumstances, and this is for any one of the objectors, we ask people to report on noise nuisance. And it is striking that in this case, even though you say you are constantly worried by this, that we have only one report to noise nuisance in 24 months. And we also do not have any indication or report from the police to say that there have been a problem with these premises. So I'm just asking out of curiosity why you don't register your concern with the noise nuisance. It is perplexing for us to see that there is one complaint, and yet to hear you, what you're saying, it doesn't quite add up. So perhaps one of you could explain that to me.
That's a very good question. Who would like to speak?
Can I just butt in here quickly before they
please.
answer? I just wanted to say, yes, obviously they can register their complaints with the police and noise and nuisance, but also the evidence they give today and any hearsay evidence can also be taken on board. They don't just have to register the complaint, although it is helpful. Today's evidence is also brought up for consideration and can add weight to your decision.
Okay, that's very helpful. Thank you.
Can I just add? I was in constant communication with Matthew Evans, and he's well aware of all the nuisance this created. I haven't reported anything in the last months because I'm too scared. I'm even scared to speak here.
Councillor Schmetterling, did you have a question?
Yes, thank you. I just want to address the last bit about being too scared to question. I mean, I have to say, why would you be scared? Just because they look at you like that? I mean, this is the United Kingdom, not some other place. But you can answer that in a second, because my question to you, the last speaker, which is Flaminia, I think, Miss Flaminia, but also the one before, I didn't, because they're all under the name under the video is Sophia G. So I'm not sure. There's obviously somebody's machine and everybody's in it. The applicant did address some of the questions, and I just wondered if you'd heard them. For example, the serving outside of alcohol, which we received the pictures a while ago. The applicant clearly stated that that was not a sale, but just having people around to try out different wines for sale. And I gather that happened the second time, but that could be the same thing. I know the number of chairs on that footway extension probably exceeded the license, but the point is that there wasn't a commercial sale, and in the objections expressed now, that wasn't referred to. So I just wondered, the question is, why did you not take that on board? And next is the thing about the mews behind you. First of all, I take it, because I'm looking at it on the satellite view, the back of the restaurant appears to have a big tree in it. So your back garden is next to the tree. Is that correct? And have the mews behind objected? Thank you. Why haven't they objected to the smoke and the noise and so on? Thanks very much.
Who would like to answer that?
The neighbours, as I explained earlier, are terrified. They're afraid to speak.
And I'm sorry, I think also in terms of the smoke transference, I mean, the mews that backs onto their garden, doesn't have windows facing it. It's a much further distance away from the windows.
Oh, I see. I didn't realise it. Yes, I can just about see that looks like something, an opening or something, but there's no windows. Apparently, yes, I didn't realise that.
But, I mean,
you raised surprise.
You raised a good point about the alcohol, because we have read the explanation. We weren't suggesting there were necessarily we weren't. That was already on record, so we didn't want to go over it. There's very little time to do so. But both occasions they broke the other license in terms of the chairs and tables license. And again, I know, it's hard to explain, but it's just this pattern of behaviour, and we see, we're very concerned that with an alcohol license, the noise and disturbance and the nuisance, frankly, levels will get exponentially higher, because they don't really live by the restrictions. We have a perception living right next door that they just don't think the rules apply to them, and if they can bend the rules, they will.
Okay, thank you. It's just I'm a bit concerned about this fear, and it's not being reported to the police, because if it's a fear of intimidation, I mean, what can they do? They could introduce, I don't know whether they could intimidate by looks and so on, but are they going to come and beat anybody up? I mean, even if there's a fear, it should be reported to the police. That's the thing, and we don't appear to have seen such reports, so I don't understand why that is.
Thank you. Now, any more questions from the committee? We'll move on to...
Thank you, no, not at the moment, not until we get to conditions.
Okay, so questions from the applicant. Mr. Stott?
Madam, thank you. I will not ask any questions about the allegations that have been made in respect of causing fear, looks, crossing arms, or matters like that. But Madam, you will understand, and I state it for the record, that because I don't ask any questions about that, doesn't mean that I accept that on behalf of my client. He absolutely would reject that he has ever been intimidating, or any of his staff have been intimidating, or that there is any such material that is garnered of that nature at all. So I just want to make that very clear that I don't accept that. But the two questions I have, firstly for either Mr. Menon or Mr. Rickards, which is, it just wasn't clear to me whether they are the occupants of two separate flats within Walton House or one flat within Walton House. And then secondly, I don't know whether it's possible to have the picture of the back garden pulled up by the officer. Yes, I think, was there another one? Yes, that's probably a better one, because I think that shows the wall between the Walton Cafe and the premises, which Karen Spolzer and her daughter own, but as I understand it, don't currently live in, and instead rent out on a short-term basis. My question to them would be, I think it's whether it's right that in fact there are no windows on that side of the cafe at all, the side to their house, and that also that wall that we can see there is so high as to prevent anybody inside the rear area of the cafe from seeing into the garden area of the adjoining premises. So those are my two questions.
This is incorrect. This is utterly incorrect. This is not our wall. This is not our building. Our office is not a wall. and it is straightly adjoining on the other side, which is not shown on the picture.
And we have direct windows.
You have shown pictures.
We have 3 windows
that
accessing that garden.
Curated in such a way as to show none of the exposure that that our house is subject to.
Is there another photo available?
I think this looks like it's the other side. It's not the premises.
Exactly.
It's the other side.
Okay. So can you see it from this photo?
No, I don't think so.
I'm asking the objector.
No. Sorry. No.
So that would be the 4th wall that you're talking about that we don't see in the picture. Can you please explain? Countess Bolza?
All right. The left wall that is now shown on the picture partially, this is the one that goes out onto a garden, but it's shown from an angle and in a way that it looks much higher than it is. The wall only goes up to where the blue bit is, and the rest of it is greenery, which we share from the other side.
I see.
But just to clarify, it's the houses in the Mews that have no window to this back garden, but our house has 3 windows.
On 3 levels.
Yeah, 2 windows. Four windows. Four windows
3 levels.
that directly go to the garden side. So we have the noise from both the back side and the front side, and this back wall amplifies the sound.
They have full view into all levels of our house from the coffee shop, from the garden. Full view, and from the street. We're happy to submit extra photographs if there is any doubt on this, because these photographs have quite obviously been curated to their advantage.
Madam, can I point out these are the photographs taken by the licensing officer, not by my client?
Yes, thank you. That's helpful.
My question was whether there are any windows in the cafe that overlook onto that left-hand side, as we see on this picture. And I think the answer is that no, there aren't any windows in the cafe that do. Obviously, there are residential properties above the cafe that have windows out the front and back, and you've got a submission from one of the neighbours. I hope that I have my questions clear.
Okay, are there any other questions of the applicant? Or any other questions from the legal advisor?
Madam, I had one question for Mr. Rickards and Mr. Menon, sorry.
Okay.
Yeah,
Which I did ask.
in case we're in the same flat, yes, we are. We are living in the same flat. We are actually a married couple. Just above Dining's restaurant.
Thank you. That's all the questions I had. Thank you.
Thank you very much. Any questions from the legal advisor?
Yes, just one quick question. Can we go back to that photo quickly, please, that was on the screen? I just wanted to clarify. So looking at the photo to the left, does the brick wall stop where the green starts? And then the shrubbery is from next door's garden, is that correct?
Yes, that's correct.
Well, Madam Registrar, that's not correct. The brick proceeds up about halfway into that greenery area. It doesn't stop where the green starts.
Okay.
And the window on the right?
I think that's into a commercial premises on the other side.
Okay.
And that's
Can I
overhanging
just make a
shrubbery.
clarification? Because the wall, it does go a bit higher up, but it's partly brick, then it's wooden, mixed with greenery. So the brick wall is only until that part that is shown in the picture.
And is that your shrubbery that's kind of overhanging?
They've put it on.
Ghastly artificial shrubbery. We have proper shrubbery on the other side.
So what we can see is the artificial shrubbery, I understand.
Which they've put on, and it's hiding the wooden panel behind that.
Thank you.
But the brick wall is not high.
But can you, at standing height, you can't see it standing height on your side of the garden into the cafe?
Yes, if we tiptoe, yes.
If you tiptoe, okay. Thank you, that's all my questions.
Can I just ask, what was the neighbor you had before the cafe took over?
There was no neighbor. It was an empty space.
An empty shop, okay.
There was for a time a very nice,
there
very
was-
quiet little coffee
Yeah,
shop.
no, no. There was for a time interior design shop that sold furniture,
Mm-hmm.
and then they moved out, and then there was a coffee shop that tried an attempt, but at that time the use of that space could only be used as a shop. So an enforcement order was put in place, and the coffee shop had to close because it was illegal at the time.
Yeah, I'm more concerned whether or not you there was a noise nuisance beforehand.
Never ever.
Well, with this short time that it was illegally operating as a coffee shop back 4 or 5 years ago, yes, it was a nuisance.
Great. Okay, I will now
But
hand over. Yes, go on.
Sorry, please bear in mind that on the other side, it's all residential gardens, with the exception of the jeweler, but she doesn't use the garden, and she's very quiet, and she's been there for years and generations. But all the other houses that have a garden on the other side are all residential properties.
Thank you. Any other questions? If not, I will hand over to our legal advisor, Ms. Lynn Masurier, to deal with the conditions.
Thank you, Chair. Can I ask that the draft conditions, which have already been circulated, be put on the screen? Thank you very much. So I'm going to just go through the conditions. Obviously, where it's marked in red, it's where I've added to or amended. So primarily aimed at the applicant, but if anybody has an issue with any of the conditions, any of the objectors, they can chip in, please. Right, so number 1, this was offered by the applicant. Mr. Stott, are you happy with this condition?
I'll keep my mic on throughout this part. Yes, and in case there's if this speeds matters up, I can indicate we're happy with all those conditions.
Okay, I'll speed through them quickly then, but obviously it just gives everybody on the live stream and the objectors a chance. Are you happy with condition 2 with my additional words in red?
Yes, it can just be moved down slightly so we can see it, I think. Yes, thank you. Yes.
Are you happy with my alternative wording for condition 3, please? I might have to tweak that so I wasn't clear what the on sales and what the off sales were, but you've clarified that the on sales include the 2 tables and 4 chairs at the front. So I might have to tweak the conditions where I've assumed that they were part of the off sales. But are you happy with that condition tweaked accordingly?
Yes, thank you.
Thank you. Right, this condition here, I'm going to number 4, I'm going to slightly tweak it. So it's broken down into 2 parts, the rear external terrace and then the front part. So in relation to let's go for the rear external terrace bit first of all, and this is where the objectors may want to join here. The external rear terrace area shall be kept clear of all customers between 8:30 p.m. and 0800 the following day. I presume you're happy with that because you suggested that. Have the objectors got any comments on timings here? Obviously, this is just a condition session if the committee were minded to grant.
This relates just to the rear?
Because yes, I'm going to do the front bit in a minute. I'm just doing the rear terrace area at the moment, the second bit. Are you happy with those times? Customers to be off the rear 8:30 p.m.
Sorry, just...
No, we're not happy with that. We're not happy with this.
What are you suggesting as an alternative?
And we're also not happy with it starting at 8 in the morning. It's a very long stretch of time.
What would your suggestion be for the committee to consider?
I don't even, God forbid that they would even consider granting this license. It would be completely absurd. I mean, certainly a much earlier closing time, like 6:30, and a later starting time. We don't want to wake up before 8 in the morning, 7 days a week, on a Sunday, on a Saturday.
What time would you suggest?
Well, not before 10.
Right, thank you. Right, did Mr. Rickards or Mr. Menon have any comments on those times for the external courtyard area?
Well, just an observation. I mean, the applicant refers to Dinings SW3 as an example to be governed by. yet they are restricted and cannot use outside space because they're overlooked by residents, as indeed is the Walton Cafe, after 6:30 p.m. because they're deemed to be a tolerated business, not an encouraged one. And if they draw the parallel, then surely that's a precedent example.
So you're saying customers out of the rear at 6:30 p.m. until when?
Yeah.
And when reopen when for the rear? Is 8 o'clock okay with you?
Sorry, 10 a.m. the next morning, as we heard.
Okay, thank you. Right, so the councillors can consider that. May I ask
a question about this? May I ask about this condition? Given what's been said, I wonder, can we put a timing on when the furniture is actually being handled? Because one of the objectors at least did say that it starts very early in the morning, moving the furniture, although the time wasn't specified. I just wondered if we can specify a time related to the, when it has to be unusable, I don't know, within 15, 20 minutes of either side of the numbers. I suppose
the question to ask is, are the tables and chairs brought in every night, or are they just rendered unusable?
But even that, I think, can create a noise. I agree with you. I mean, that's correct, of course, that's right. But I mean, it still makes a noise. So whether one could specify a time.
But don't forget that the opening hours will go on longer than say, for example, if you went for the 6:30 bring in, I mean, the inside of the shop will still be operating beyond 6:30, so they wouldn't be able to bring in the tables and chairs then. So you have to bear that in mind. I mean, render unusable, and obviously, so we'll have to have a think about that, but you have to bear that in mind too.
Okay.
We might want to suggest that the tables and chairs are left outside, because that will make less noise and nuisance for the neighbors than bringing and unchaining and taking tables in and out. It's just a suggestion. I don't know what Mr. Stott thinks about that.
Well, Madam, your advice makes a good point about bringing them in when the inside is still being used, because obviously there's the space issue. I can see a way in which you could leave the chairs out but bring the cushions in. And obviously we want to bring things like soft furnishings like cushions in, but I don't see that making much noise.
Well,
it's something to take on board.
Yes, it does not say what render unusable means. We don't know if it's going to be taken inside or not.
Yes, well, obviously, in terms of the outside area, it can be simply closed off, the rear terrace. I mean, there's a door. Equally, the park bay can be rendered unusable, as I think they normally are down that street and elsewhere.
Thank you.
Thank you.
Okay, so the door could be closed, which could prevent customers going out there, and presumably the tables and chairs can be left out overnight or rendered unusable another way.
Yes.
We're talking about the back, yes.
Yes, the back here. Now moving on to the front area. So there's obviously the on sales, which relate to the 2 tables and 4 chairs directly next to the shop. And then there's the off sales, which will relate to the parklet terrace. I'm going to tweak my condition so that we can have timings in here. So it'll be similar. All tables and chairs in the front external dining area, so that's both parts, are to be rendered unusable and or removed from the highway. And I'm going to duplicate the times between 8:30 p.m. and 8 a.m. the following day. Can I have your comments regarding the front area on those times, please? Is it the same as for the back area?
What about the 10 a.m. that was suggested by the objectors?
Yes, because it's
anyway, that was suggested.
I don't know. For the front, I don't think it's fair because it's a cafe. They should be able to serve breakfast if we ground.
But why should I be woken up by the chairs every single morning, including weekends at 8 a.m.?
I think what you've got to bear in mind here is that they've already got a highways license to put the tables and chairs out in the times in accordance with the highways license, so they can do that anyway. Obviously, whilst we don't have to duplicate regimes, we have to kind of bear in mind that this cafe can operate without a premises license to serve anything without alcohol,
yes,
such as breakfast. So I think we have to be appropriate and proportionate in our approach to the front area. They've offered between 8:30 and 8. Is that correct, Mr. Stott, for the front areas?
Madam, yes, that is all that's been offered.
You're happy with that condition. So turning to the objectors, bearing in mind this is the front area rather than the rear garden area, what are your views on timings for the front area? Bearing in mind that they can have tables and chairs out anyway, and they can serve breakfast anyway without the British licence.
Can I just
So
ask, why does alcohol need to be served at 10 a.m.? I mean, most people don't drink alcohol at that time in the morning.
Well, it doesn't have to be served at 10 a.m. Obviously, they're asking for it from 11. That's when they're asking to start for alcohol from. They may or may not serve it later. But they can still serve food and tea and coffee and breakfast. They can still put the tables and chairs out, but we can't prevent
I'm aware of that. But shouldn't an alcohol license, if it is granted, which I really very much hope it's not, but shouldn't it start much later? I mean, if we have people starting drinking that early and they stay there all day, they're going to be totally wasted by the end of the day.
Well, that's for the yes, the committee can take that on board, and the committee can make a decision about the hours. They obviously can't extend hours, but they can reduce hours, and that's something that they can certainly take on board.
Please, could you take that on board? Reduced hours, if it's granted, which I hope it's not.
So that's for the hours for the actual on and off sales you're asking about. But in terms of this condition, the tables and chairs out the front, which obviously they've got the licence for under the highways regime, what are your comments on the hours? The applicant is saying that they'll be put away or rendered unusable between 8:30 p.m. and 8 a.m. the following day. Are you okay with that? If the committee were minded to grant, obviously your first position is refused, I understand.
No, obviously not. I'm not. I'm totally against it.
Okay, so Mr. Rickards, Mr. Menon, do you have any comments on this bit?
So just to clarify my understanding, because, some of this wording implies changing the hours in, so that they comply with the highways license, which is, to our understanding, outside the front till 10 p.m. So there's also times being banded around.
I think for the highways license, yes, they are two totally different regimes, and yes, it would be helpful if they all tied in together nicely. I agree, but this is a separate regime. So technically, under the highways license, they can leave them out there till 10. But if we impose an earlier time on the premises license, which they've agreed to, and they don't do that, then they'll be in contravention of the premises license.
So they will cease serving alcohol at 8:30 p.m. Is that what we're saying?
At the outside area.
In the outside area.
Yeah, not inside the premises.
May I seek clarification, please?
Yep.
They have, under the highways license, 2 licenses, not one.
Yes.
One license on the pavement.
Yep.
Under the highways license allows them to have 2 tables and 8 chairs.
Hang on, I think we've got 2 tables and 4 chairs, the ones directly next to the premises, and in the parklet bit, 4 tables and 8 chairs, I understand.
That's it.
Yeah.
They have suggested replacing their application, the external seating area and rear roof area, so they've clubbed the 2 together, should be kept clear of all customers and rendered unusable between 20:30 hours and 800 hours the following day. They wish to replace that with, and I quote, all tables and chairs in the front external dining area are to be rendered unusable and or removed from the highway in accordance with the times stipulated in the separate highways license.
I've just amended that verbally when I started this, So I'm kind of taking out from in accordance onwards and going to replace it with the earlier times, which will be more to your advantage.
I'm very, very much obliged to you for that. But may I suggest that in the unhappy event you are minded to grant them an alcohol license, that the alcohol license for the external pavement and covered pavement area dovetails with the hours for the Courtyard, which is 6:30 p.m.
So you want, all right, so you're saying 6:30, so no tables and areas to be kept clear from 6:30 p.m. to, are you going to say 10 a.m. again, or are you going to say 8 a.m. so they can have breakfast?
No, I'm talking about the alcohol.
Sorry, the alcohol license will finish at, well, they've asked for 9:30. With this condition will, by virtue of the condition, stop them serving alcohol outside because we're asking them to keep the area clear and to remove the tables and chairs.
Yes, what I am requesting the committee, in the event that you are minded to grant them this alcohol license, and we urge you not to, that the external seating area on the public pavement is also limited to 6:30 p.m. in the evening.
Yep.
For the purposes of alcohol.
All right, okay. But that wouldn't stop people having, so I'm just trying to think out loud. So if you're saying just for alcohol, they could have non-alcoholic drinks and they could still eat. I mean, really and truly, we need to think what time you want the tables and chairs to be rendered unusable. Sorry, Councillor Rossi, you wanted to speak?
Yeah, I don't understand why. We have our tables and chairs license, we have highways license. I don't see how with the alcohol license that we can change what they already have out the front. I don't see that we have that there's any reason to do that actually.
Well, the highway stroke pavement license is just to physically put the tables and chairs outside. It's not to do with serving alcohol. So in an ideal world, yes, we would dovetail them all because it makes life easier for people to understand all around. I totally agree. But they have offered, by way of condition, to make the areas unusable so people can't drink alcohol or any alcohol or soft drinks or food after 8:30. So they're happy to curtail that to address your concerns. But you're obviously saying...
But now you're saying 6:30.
They're saying 6:30.
I'm getting concerned that we are using one license to change another, and I don't think we're on very strong grounds legally to do that.
You can, it is a clash, I agree, but it is possible because again, it's separate regimes. They've offered 8:30. It's not something that we're imposing, it's something that they've offered. So I suppose at the end of the day, they could just render the tables and chairs unusable, but just leave them outside until close. But no one can have alcohol out there after 8:30.
I think we need to discuss that.
Yeah, I think it's something we can discuss in the session afterwards. I just wanted to get thoughts from the objectors. So they're saying for the front areas, stop at 6:30. When would the restart be? The applicant's saying 8. You're saying...
This is for the presence of tables and chairs as opposed to alcohol. I thought we cleared that, right? So they're allowed already to have tables and chairs by 8. And alcohol is proposed to start from 11.
Well, they're asking for alcohol between 11 and 9:30, but obviously we can add conditions to the licence, and they've offered a condition. So in respect to the tables and chairs outside, which they've got a separate highways licence for, you're asking, rather than being rendered unusable at 8:30, as they're suggesting, you're saying 6:30, and then they're saying restart again at 8 o'clock. Is 8 o'clock okay with you, is what I'm trying to work out for the front area?
So I think we're still running some confusion because the 6:30 was for alcohol, not tables.
So you're saying, okay, so there's the separate question of what times the alcohol licence should go from.
Yes, that's right.
That's fine. We can consider that separately. But as a separate issue, and obviously if the committee were minded to have a 6:30 M for the alcohol, then obviously we would dovetail all the other conditions. But we're looking at the condition before us now on the basis that it's 11 till 9:30. I'm just kind of trying to get clarity on what you think is acceptable for this condition. We tweak it accordingly, depending on what hours the alcohol licence is granted for.
may I suggest that in the event you are minded to grant them a license, that the opening hours commence from, say, 9:30 or 10 a.m.
Okay, I think we're going to leave this to members to
make
the decision. Okay, I think I've got the gist of what you're saying. You ultimately you don't want alcohol going beyond 6:30 if minded to grant, and obviously the members will take a view on the tables and chairs conditions. Mr. Scott, have you got anything to add at this point?
Can I just add one point with regard to the table? Sorry, it's Sharon Dyball speaking.
Oh yes, thank you.
Just one point with regard to the tables and chairs licenses. The hours for the Sunday finish at 8 p.m.
Oh, okay.
Monday to Saturday, the hours for the tables and chairs finish at 9 p.m. They do have different start times for the forecourt and for the Parklet Terrace. The Parklet Terrace hours start at 8:30 Monday to Saturday and 9 o'clock on a Sunday for the tables and chairs. Whereas for the forecourt, the start time is 8 a.m.
Okay, so we need to go away and make a decision and then tailor everything so it all ties in and makes sense, basically.
Yes.
Okay, understand. Thank you. Right, okay, sorry.
Do any of the governance officers have anything to add?
Oh, we haven't got to that bit yet, Chair.
Oh, okay.
We'll still go through the conditions, sorry.
Oh, okay, so sorry.
Number 5.
Yeah.
Are you happy, Mr. Stott, are you happy with my slightly tweaked wording? You're on mute.
Absolutely.
Thank you. Number 6, are you happy? I think 6, 7 and 8.
Yes.
You've offered. If the objectors have anything to say, please speak up. Number 9.
Yes. I have.
Sorry, could I
speak up?
Yes, please do. Who's talking?
This is Flaminia speaking from 50A Walton Street. Can I just say the smells? How are the objectors going to get that down? And the noise and music associated that I've seen in the report and that they plan to do. I mean, it's going to turn into a disco, it seems. They want to install some loudspeakers in our rear garden next to us. We already have a lot of nuisance since they're operating. This is just going to aggravate it, particularly if an alcohol license is granted. So I'm not sure how they can guarantee this. How are they going to comply with 6, 7 and 8? That's my question.
Okay, I think the answer, I mean, Sharon can jump in here regarding regulated entertainment, which they haven't applied for. Things like smells and noise nuisance fall under the domain of environmental health. So obviously, if there's any breaches there, then they would be dealt with by environmental health. Regulated entertainment, I think they're just allowed to play incidental music at the moment. Is that correct, Sharon?
Yes, so at the moment, because they're unlicensed, it is only incidental. If the premises are licensed, then recorded music can be played. It doesn't become a regulated activity until after 11 p.m. at night.
Thank you.
Well, I object to the playing of music because when they were building the illegal roof, the workers were playing music 24 hours, basically, whenever they were there on the premises, and it was extremely disturbing, particularly at times like now where we're all working from home.
What about not allowing at a certain time music to be played outside? How would that work with music on the terrace? Have we addressed that?
Is music going to be played on the terrace, Mr. Stott? Do you know?
There is no speakers outside. As I understand, there's no intention to put speakers outside. I'm not sure where that comes from.
There were speakers. There were speakers outside until very recently.
You said it was from the builders, didn't you?
No, but it was installed speakers that they installed on the wall. I think they may have removed them, but I understand the plan is to reinstall them, from what I've read in your application.
Yeah, I'm Elizabeth Bowes. I'd just like to make an addition to this comment. I was at our house yesterday in the garden. The speakers have been removed. We have photographs of those speakers. They attached illegally to the protected building. They still have the base that holds the speakers in place, presumably for them soon to be used again.
Can we put a condition in about outside music, please?
Yeah, we can go away and look at that in the private session about I mean,
Could we
bearing in
please
mind that
refuse outside music because it's a residential garden? Why do I need? We already have all the nuisance from the fume, the smells, the people speaking and smoking outside and being loud and using foul language. Why do we also have to have music on top of that? It's very disturbing.
On board. That's why I asked for us to discuss it. Thank you.
Thank you.
Madam,
Thank you very much.
Madam, there would be no objection to a condition prohibiting the playing of music outside in the rear terrace.
Okay.
Sorry, I didn't get that. Lindsay, did you pick that up?
Yes, Mr. Stott said he'd be happy for there to be a condition for no music to be playing outside.
Right, that's customary.
Is that no music altogether, or are you talking about excluding incidental music?
No amplified music.
Okay.
Yeah, it's not customary in the borough to have music outside.
Okay. Right, let's move on. So
Sorry, could I ask at this point about, we're talking about smells, condition 6. What about smoke? I mean, that's not from cooking, obviously, but it's from the clients. Is there anything one can do about it? Because obviously they have to have some sort of smoking area.
Well, where is going to be the smoking area? Perhaps we can have a condition. I think I've got one later on about smoking areas, and perhaps Mr. Stott can help us out where their smoking area is going to be. Is it going to be outside in the back garden, or is it going to be outside in the front?
I'm just looking to find that condition.
I think it's one of my suggested ones.
17.
17, thank you. Yes, I see. I think currently they're smoking outside, front and back.
Okay.
Sorry, Flaminia speaking. I really oppose to this. I mean, as mentioned in both of our statements, we can, with our windows closed, we still have the smell of cigarettes, cigars, and food inside our house.
So, Mr. Stott, would your client be willing to have a condition whereby there's no smoking in the rear courtyard area and it's just out the front?
Well, the issue is that there needs to be smoking areas. I mean, I do find it difficult to understand why the smell and smoke would be so bad when the hours are going to be limited in the way that they are going to be limited. But if, as I say, Mr. Cherry is very happy to comply with any conditions that will be imposed.
Okay.
Lindsay, is it possible to put in a condition that there'll be no cigar smoking in the back? Because that's a whole other kettle of fish, isn't it?
Perhaps that's something we can look into in the private session. Okay.
Yes, I can endorse that. Certainly, cigars do have a particularly pungent aroma.
Okay.
Just one last question, because I plan to very shortly start a family, and this is really true. So can we not put a condition that there's absolutely no smoking in the back garden? It's my residential garden next to it. Why do I need to be smelling cigars? And why do my children have to be exposed to cigarette smell? Not only cigars, just normal cigarette smell.
So your preference is there to be no smoking in the rear?
So no smoking in the garden, please. That's my preference.
Okay, we'll leave that to the councillors to decide. Let me just make a note of that. No smoking in the rear. Thank you. Right, let's go back to the conditions we were looking at. So I think we've covered 6 and 7. 8 and 9, they're standard conditions. Mr. Stott, you're presumably happy with them because you offered them.
Yes, just to reiterate that I had suggested an addition to deal with the complaint that had been made about the leaving of rubbish, though I don't necessarily accept that it does happen to an unacceptable degree by my client. But in 9, no refuse to be left on the eastern side of the carriageway or footway.
On eastern side.
If my compass directions are correct, I think that is the Walton House side, the eastern side.
Outside Walton House, basically. I'll check that. Okay.
Can I just point out something here? Because as soon as I step out of my house, I see all the Walton rubbish, all the rubbish from the Walton Cafe right next to my footstep. So, I mean, could we not find another alternative where they can put the rubbish that is not so close to my entrance?
Or they can put it directly outside the premises at the times, and obviously we can speak. Perhaps that can be dealt with through the residents' meeting condition.
I'm just wondering, that presumably the rubbish collections are at known times.
Yes.
So can we specify that the rubbish shouldn't be put out, say, more than half an hour, I don't know, an hour before the collection time? But obviously, there's got to be some flexibility to allow for variations. But
do we know how many collections there are per day, or is there one a day? Do we know what time it's at?
As I understand it, I'm so sorry, madam.
Yes, you're using RBKC rubbish, aren't they?
Yeah.
So
yes. Mr. doesn't know the precise time, I'm afraid. It's in the evening because he puts out rubbish when the premises closes, and it's, as I say, collected shortly thereafter. We would then be slightly in the hands of RBKC waste, which obviously Mr. Cherry can't necessarily control any changes they make. Sometimes I think at short notice.
So your client's putting it out at the close of play anyway, after they've finished operations. So it's not on the street during the day, it's at the end of the day.
That's his practice, yes.
Okay.
There is an 11 o'clock collection with RBKC.
11 p.m, madam.
Yes.
Well, then that must be it.
And there's a 4 o'clock in the afternoon.
in that part of the borough.
Yes, but if they're closing early, we have to take that into consideration.
Okay, so that's something that we need to just take
We
on.
need to discuss that, please, yeah.
Right, number 10. Are you happy with my alternative condition? Obviously, I need to tweak it in respect of on-off sales.
Yes, obviously the plan is waitress or waiter service. It's been clear that this is to be seated rather than vertical drinking.
Thank you.
Can I ask a clarification on that point? Because our understanding was that the proposal was to serve alcohol at tables with the consumption of a meal.
I think that's one of the later conditions. Let's have a look.
Shouldn't be in here.
I think let's have a quick look.
It's one of the earlier conditions, I think.
Oh, is it one of the earlier ones? Yeah.
I think so.
Yes, number 3 covers that. So these two conditions combined cover that.
So we should maybe put them next to each other.
Yeah, so it's ancillary to a meal, by waiter waitress service, seated.
Good point.
Yeah, they should be adjacent to each other rather than.
Yeah, very good.
I'll do that when I do the if you're minded to go on. I'll do that. I'll put the conditions together. It's just the way that they've been offered that I've kind of kept it to that format.
Yeah, okay.
Right, okay. So number 11, this is about drinking up. So presumably you're happy with that condition because you offered it.
Yes.
Now, whilst we're just on this bit here, talking about obviously your clients apply for Monday to Sunday on and off sales 11 till 21:30, and opening hours 8 till 22:30. I mean, did the councillors have any questions about times of alcohol sales on Sundays or drinking up times?
Yeah, I think we were thinking about an earlier time. Because if you go till 9:30, we also have to look at the rest of the street. But 9:30 makes it till 10 to drink up, correct?
Correct.
Then they
and
have
then the opening hours until 10:30. So what more do you have to say on that? Sorry.
Well, we just have to take into consideration, I just want to balance, they've got to clean up and put the rubbish out, etc. So we have to discuss that in private, what hours to give them.
Yes. So Mr. Stott, if there's like a half-hour drinking up times, and if the committee were minded at 9:30, so that would take us to 10. Would your client be agreeable to the opening hours being reduced to 10, 8 till 10? And obviously you'd be able to clean up separately afterwards.
Yes, it's a necessary part of the fact of complying with the licence that if there's a shorter time frame specified in the premises licence than any of the other relevant licences or the other opening hours, the applicant will have to abide by the shorter time frame.
Okay, and did the councillors have any view on Sundays, Sunday's hours?
What time is it now that we're asking for 9:30 on a Sunday?
Well, all week, it's Monday to Sunday, 11 till 9:30.
Yeah, I think Sunday should be earlier closing.
I think so as well, yeah.
2000 maybe.
Yeah.
Or 8:30, 8 o'clock.
Mr. Stott, do you have any views on earlier closing for alcohol sales on Sundays?
No, I don't have any comments. I repeat, the applicant will abide with the conditions.
Okay, fine. So, okay, so if the committee were minded to grant and they were thinking about reducing hours on Sundays, your client would comply with that. Thank you.
Yes.
Lindsay, can we close the backyard, the garden space? Can we close that early?
I think we've covered that already, haven't we? We said that it was going to close at 8:30, don't we?
Okay, so both we can have different times. Thank you.
Yeah, or the objectors want 6:30, but yes, we can have different times. Yes.
Can I just comment something on the use of the back garden? Could we maybe put in a condition that it cannot be used on the weekends?
I think that wouldn't be proportionate or appropriate, to be fair.
I'm being diminished the use of my private garden because of their presence. I cannot. It feels like an expropriation of part of my property, to be honest.
That's something for the councillors to consider in the private
session. We maybe
no use of garden at
on the weekends?
Okay,
please.
More councillors can consider that. Okay, thank you.
Thank you very much.
12, please. Are you happy with my alternative wording for 12, broken down into 2 conditions, Mr. Stott?
Yes, of course.
Thank you. And for 13, are you happy with my revised wording? Again, I'll have to tweak it in relation to on-off sales, but are you happy with that?
Could we just scroll down slightly?
Sorry?
We scroll down.
Scroll down.
All right, sorry. Number 13. If you could scroll down, Anne, please.
Yeah, we can't see yet what your comment is. Here we are.
Scrolling slowly.
Yes, thank you.
Yeah. And number 14, I'm happy with your 14, but are you happy to have the additional bit about the posters?
Yes, of course.
Thank you. Are you happy with 15? And we can, subject to what the councillors think, we can specifically add a couple of addresses in of residents if need be?
Yes, absolutely.
Thank you. So,
could I suggest, first of all, sorry, this is Dory speaking, Dory Schmetterling. First of all, that at least 2 times a year we should put in the usual sort of phrase or clause about the gap, so that we avoid doing it twice within a couple of weeks, like okay. With at least 5 months apart, or shorter if more than twice a year. Okay. This is at least twice a year, which is fine, because if it doesn't go well, then 3 times a year might be more sensible.
Okay,
but that's okay. And the second thing is, sorry, go on.
No, I was going to say, and what residents were you thinking? Were you thinking of?
Yeah.
Either side of the property
yards.
And house, perhaps.
Yeah, maybe could we put a radius, like 50 meters or something? Was that too difficult?
Well, I think for the purpose, well, we can consider that it's either radius, or I was going to suggest either side and opposite.
Yes, I think that's better.
But you have to define what opposite is.
Walton House.
Yeah, and also the building next to it.
Okay, so opposite means opposite.
No. Well,
look at that.
Not necessarily.
Perhaps I can just
what you mean, but
perhaps I can suggest the neighbours either side, the occupants of Walton House, and I think the old courthouse, which is a now residence, is number 1A Walton Street.
Okay, thank you. That's helpful. Thank you.
Yeah, the building next to. What about the one that's marked Lennox Gardens, but is still more or less facing the cafe?
Well, perhaps we can seek clarification on that.
Yes.
Definitely. Right. Okay. Moving on. I've obviously the conditions requested by the objectors. I've kind of commented that they've been amalgamated into other conditions. So if we can go to 16, which I think we might have covered. Yes, no, number 16. We can add that because we've already got deliveries and refuse collection. So that's just about rubbish not being put outside. So that ties in with our earlier conversation. So are you happy with that condition? Number 16?
Yes.
Thank you. Right, moving on to 17. So I think we've kind of already touched on this already. Flaminia would like no smoking in the rear. You've ultimately said your client will be happy to comply, but obviously, as far as your client's concerned, it's been in both areas. So
yes, it's a question of proportionality for the committee.
Yeah, okay, fine. So you're happy with the smoking condition that's obviously proportionate. Are you happy with the third bit about patrons permitted to temporarily leave and then re-enter, can't take glasses or drinks with them?
Yes, so I assume that would then be for the period of time when the outside area is closed off, rendered unusable, etc.
Yes, and presumably, well, if people are inside,
it may be worth something like adding a rider to say when the outside areas are not to be used in accordance with conditions above, something like that.
Okay. Are you happy with 18, the daily incident log?
Of course.
19, keeping the area clean.
Ditto.
Sorry, I don't want to delay things, but just on the point 17, just to clarify, if they're serving outside and they take their alcohol outside, does that give the risk of vertical drinking?
We're not going to allow vertical drinking. They've already said that alcohol can only be consumed with seated at tables by waiter waitress service and ancillary to food, so they can't be vertical drinking with the alcohol. I'll look at the condition and word it appropriately. It's more so about taking soft drinks outside and things like that. Right, number 20. Are you happy with that?
Yes, of course.
Thank you. 21, dedicated telephone number on display.
No issues.
22, I mean, I know you said that you haven't got takeaway service at the moment, but if your clients were minded to, then are you happy with this condition?
Yes, I suppose because there is no intention to do it at the moment, the last sentence doesn't really make sense.
Okay.
Perhaps it should be something that by no later than 21 days prior to the commencement of any service or something like that.
Yeah, makes sense. Thank you. And same really for 23. I mean, if your clients do a takeaway service, then obviously they can't just be taking away alcohol. It's got to be in conjunction with a meal. Are you happy with that?
Yes.
Thank you.
Can I add a condition here? If they do takeaway service, can please the coffee shop guarantee that they don't sit on the steps of my doorstep, which is right at the entrance, because I often have visitors from the coffee shop that sit there and smoke a cigarette after they leave. Part
of the condition 22, what do you call it? The delivery policy. That will form part of the delivery policy. I can put that in.
Yes, please. Thank you very much.
Thank you. I think one other thing that you mentioned, Mr. Stotts, was you're happy to have a condition saying no tobacco was to be on sale at the premises. Is that correct?
Matter of the committee, but yes.
Thank you. Right, I can't think of any more conditions. Has anything else cropped up that needs to be covered by way of a condition that anyone wants to discuss?
Yeah, Dory would like to ask something of the applicant. Given the strength of feeling and all the various issues alleged or took place or whatever, would you as applicant be prepared to consider, if we were minded to grant a 1-year license, and in which time the operator can actually prove the good operation, and it would allay, I think it probably would allay a lot of objectors' fears.
Well, sir, yes, the operation of the premises license is obviously, whether it's granted for a year or for a longer period or indefinite, is always going to be subject to the normal rules and normal ways in which people can raise issues as to whether or not licenses are being breached. It's a useful tool to monitor licensed premises and enforce them. But of course, if it's a year, then that would suffice. In terms of the strength of feeling, I think I would simply observe this. You've heard some very vociferous objections, but you've heard them from very specific sources.
Sorry, can I just clarify there, because I didn't catch all
Please
that.
do.
So, Councillor Schmessing, were you asking about the possibility of a temporary licence just now?
Well, yes, a temporary license of 1 year, because I mean, I agree with Mr. Stott. There are methods of review. We're well aware of it. We have here and there, just very rarely, thankfully, revoked licenses following reviews. But this is something we obviously try to avoid. Plus, it puts the onus on the residents. Whereas if you do a 1 year license, a temporary license, if you like, but 1 year, then the onus is on the operator to prove the good operation. And that's why I'm asking if reminded to agree, and it gets difficult, you know, the decision might help the decision if we know the applicant is willing to accept a 1 year license. That's all I wanted to ask.
And can Mr. Stott just clarify what his views on that were? Because obviously you've applied for an unlimited license.
Yes, obviously.
We can't impose a 1 year license unless your client was in agreement, and if the committee were minded to go down that route, and if they felt it was appropriate and proportionate. Can I just have your views on that, please?
Well, we'd rather no license. We'd rather a license than no license, obviously.
Yeah.
I mean, we have applied for the. I confess I don't know whether to be, and I'm sure I can be assisted as to whether or not you can effectively change an application for the license that we're having into a temporary Act 1.
Well, with your agreement we can, but without your agreement, we either grant or refuse.
Well, if it makes the difference, then yes. But as I say, my primary submission is that this should be the license should be granted that we've applied for with the strict conditions we have, and as the councillor rightly points out, the review mechanisms that were already in place for such a license.
Thank you. I've noted that. Right, I'm done.
I have a question.
Yep.
Mr. Stott, with regard to the condition on your client's meeting with residents, will you be able to explain to them what this means and that they certainly have to do it? It's not just something you say, yes, 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 and then nothing happens, because this is serious. We have had people with many objections, and yet we need to know from you that your people will meet with the residents twice a year, I think we said, Lindsay. What did we say?
We said twice a year, yes.
Twice a year, yes. It's very important, and they should communicate, because it's clear I don't know what they've done or not done in terms of what their intentions were, but there has to be generally very good communication between them and the residents and a good atmosphere in order for them to coexist.
Madam, yes, I can provide that assurance. The effect of all of these will be explained in detail to the applicant. He's already gone through them with his legal team. He understands them. And of course, I'm absolutely confident that some of the objectors will bring it to the attention of the Royal Borough if any of the conditions are not met.
Okay, thank you very much. So can I say we have reached the end of this meeting?
Yep.
And the committee, I thank everyone. I thank my members and all the people who presented evidence today. And the committee now has all the information needed, and we will retire to make our decision in private session. We will not announce the decision today. Instead, the hearing on this application will be closed and the live broadcast will end. A summary of the decision will be sent to the parties within 5 working days of today's hearing, and a full decision will follow as soon as possible thereafter. Thank you all for attending and giving us your time.
Could I add one last point?
Sorry?
Would it be possible to add a last point?
Legal advisor?
The meeting has actually closed now. Is it something you've already covered before?
No, it's not. It is a clarification, a point I've covered, but it's an important clarification.
Well, if it's with the chairman's permission, you can, but it's highly unusual.
Please, Miss Evans, may I make it?
I'm not happy. I think we've given you a lot of platitude today, and a lot of things that were really not even legal issues. So I'll give you 1 minute, and that's it. But I don't even know if the camera's on anymore, to be honest. Is the camera still on?
Yes, it is.
Yes, it is.
Okay, you have 1 minute.
Okay, thank you very much. I just wanted to say that when one feels intimidated, you don't always report it. And I think for any ladies who are sitting here, there are many ways that you can feel intimidated by sneers, by looks. And have you never suffered verbal intimidation? Have you always filed a complaint when you've suffered this?
I think it's very subject to interpretation, but I thank you for sharing that. So I'm going to call the meeting to an end, and thank you very much.
Thank you very much.
Thank you.
Thank you.
Thank you, Madam.
Thank you. Lindsay, our committee, should we have a 5-minute break, and then how do we go back in?
Chair, it's Anne Wright. I
Yes.
will invite you into another meeting if you leave this one.
Yes.
And I'll invite you into the other meeting.
Can you give us 5 minutes?
Absolutely.
Thank you.
Thank you.